Time is almost 7:44 on this Wednesday morning. Taking a live look now from the White House. Attorneys general from more than 20 states and Washington, D.C. are now suing the Trump administration over a flurry of major budget cuts.
Those cuts impacting everything from crime prevention to food security and even scientific research. The lawsuit filed in Boston is asking a judge to limit the Trump administration from relying on an obscure clause in the federal regulation to cut grants that don't align with its priorities.
Yeah, the lawsuit argues that since January, the administration has used that clause to cancel entire programs and thousands of grants that had been previously awarded to states and grantees. Our chief legal analyst Khalif Rhodes joining us to break that all down. Khalif, before we get into what you think of the legality of it, how are they trying to use this clause and how are they, in the judge's view or the lawsuit's view, using it inappropriately?
Well, the first cut's the deepest. They're trying to cut everything in sight, and the way they can do that is to find a way to legally justify it. I've said that a couple times before in the past, that the Trump administration has a number of lawyers in the room, and he's saying, I want to get to this location. Help me get there. Find a legal path to get there. If when you remember when you were a kid, you make those little mazes, everyone's trying to figure out how to get to the end. If in that room, someone's telling those attorneys, go, crawl through the books, figure out a legal, legitimate way that I can get to the end goal that I'm trying to. And they point here to this clause that's in the Office of Management of Budget that says that they can get rid of, any funding or any program that's already promulgated by Congress if it no longer effectuates the program's goal or agency's priorities. And so they've used that for everything. Any program for crime prevention, for youth, advocacy programs, for feeding programs in smaller or urban communities. Those are the types of things they're getting rid of because they're pointing to this individual clause. Plaintiffs on the other side are saying, well, hold up, you can't use that clause for everything that you, as one attorney general said, that you don't like or that you don't consider to be effective anymore.
All right, so kind of take me through the legal step here of these attorneys general. Like, what is the plan to try to stop the Trump administration from picking and choosing which programs get cut and which ones stay?
Typically, you look at precedent. So precedent with court cases would be looking at how the court has ruled on these in the past. But specifically, when you're looking at something that a government agency has done, specifically a rulemaking agency, you look at the legislative history, the intent, why they came up with that rule. Any rule that's promulgated will have an open question process where people from the public can, submit questions. And then they'll go back and forth. And then there will be a finalized rule. But during that rulemaking period, there will be a number of back and forths. You'll look and see what that back and forth was about. And typically this back and forth in this situation will say, we only wanted it for some small set. We didn't want it to be a whole, a machete approach. This was more like a scalpel approach. So that's what the attorneys general are attempting to argue, that that was not the intent of this rule, that this rule was not for the president or anyone else to be able to wholeheartedly gut congressional funding, because then you wouldn't need a congressional approval process. You can just say, hey, the president can get rid of or approve funding as he needs. That wasn't the goal. This was really a way to make it efficient so they wouldn't have to go back to Congress when they wanted to get rid of things on a smaller basis.
We talk about lawsuits a lot in the administration here. So where do you see these particular lawsuits going?
I'm not sure. Previously I would have said in previous administrations, or I should say previous renditions of our Supreme Court, I think this would have been a clear-cut example of just see what it says in the history, see what their intent was, and follow that path. This court has been extremely supportive of the President Trump, and I think historically trying to ensure that they cement the authority of the president, not to increase or decrease, just to ensure that it is separated. By gauging that, I couldn't tell you. I really think that if this was 10 years ago, I wouldn't even have to blink and say instantly this would be going the way of the attorney generals that filed the claim. Today, I'm not sure.
Okay. Our chief legal analyst Khalif Rhodes there with the analysis. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.